Welcome to Cannabusiness Live. I'm Craig Aronoff.
Travis Copenhaver.
We're here from the Cannabis Legal Group. Sorry about the quick, a couple technical difficulties there to get started, but we'll just assume we're all good now.
Yeah.
Thank you for joining us. This is episode 50 of Cannabusiness Live. As always, we'd appreciate you asking questions throughout today's show. Like us, share us, tell your friends about us. Certainly, if you have questions during or after the show, feel free to reach out to us. We do have our link at the bottom of the page there. We still maintain our municipalities page. These videos are available on our YouTube link. Please subscribe. We have kind of a unique show today insofar as we're going to be talking about Rule 19, temporary operation. As Travis and I prepared for today's show, I think it's pretty fair to say that we're not necessarily in sync on everything about it, which would hopefully provide a better, healthy debate. And you might see us talk the way we always talk in our
a little more candid visual, yeah.
Yeah, and then we if you can't imagine, Travis and I, Nick and Barton, we do spend a lot of time talking about the MMFLA, the MMMA, and all the different aspects of this law and different ways that it impacts our clients and operators throughout the state of Michigan. And so this happens to be a topic that is kind of made the forefront due to some press and to an enforcement action that came out last week in Detroit. We'll talk about that briefly in a minute, but just kind of want to reiterate that as we read the statute, as we read the amendment to the statute, as we read the rules and then the amended rules, the extension of the rules, there is definitely some ambiguity and some lack of clarity from the state as it relates to this temporary operation and what risk people will take if they do presume that they're allowed to act like a licensee before they have a license. And so with that caution in mind, and you'll kind of hear us relay that as we go, let's just talk about briefly what happened in Detroit last week. I guess it's actually about 2 weeks ago now. But there was a lot of news about a facility, a multi-million-dollar facility that was set up, and according to the police sergeant who was quoted on Fox News, was really designed to take its product to the black market. The reality of that was this is a facility that was on the list from the city of Detroit, had received a temporary attestation, had been approved through BC and the BZA and everybody else, and actually had received a wrongful cease and desist that was corrected by the state. And so despite having all of the relevant paperwork and everything that they were supposed to have to be operating within the rules and the structure of Michigan's new law, they were still enforced upon and had their plants taken and are still defending the civil forfeiture at this point. Mm-hmm. So, that... hello again. Welcome back to Cannabusiness Live. We apologize. Our Wi-Fi is having some issues. So
they're doing some road construction right outside the house. I'm sorry, right outside the office, and it's really making our connection spotty. So we're doing our best here, and apologies if we go in and out.
Yeah. Hopefully it's stable now, and we'll continue. So again, welcome back to Cannabusiness Live, and we're going to delve into Rule 19. And I was just kind of briefly talking about the synopsis that occurred in Detroit. I don't know if you have any commentary past what I've mentioned on it, but...
Specifically for Detroit, not really. I have said several times, I think on these videos and definitely in consultations with clients, that while I understand the need for and I appreciate the temporary operation provisions, I hate it. I think it is just begging for problems, and unfortunately, for at least one operator in Detroit, they're experiencing those problems firsthand. While I feel the need to provide products to patients is incredibly important, and I applaud the state for trying to create a system to accomplish that and allow for operators to do so while they're seeking these licenses, especially considering we face a lot of delays. The way they've laid out temporary operation and isn't very clear, and it doesn't make a lot of sense when you start extrapolating, okay, what does that really mean and how's it supposed to work? And I have counseled most people that ask me, should they do it? I would say, you can, but I wouldn't recommend it. I think it opens a lot of problems. If you want to be a long-term operator, it raises a lot of questions if in the short term you're going to get a license at the end of the day. But I don't think we're going to focus on, why you should or shouldn't be a temporary operator. At this point, if you either can or you can't, that window is closed. But since we do know that they're out there and we have seen some consequences of those operations, we should discuss what the system is and how it works, and that's really the purpose of what we're doing here now.
Yeah, and I think, and you'll see that from time to time as I was reviewing my notes and everything, this is one where you've probably seen Travis and I in the past riff off of, and we always try to be very prepared for our shows. There's some very unique things about this particular discussion that we want to make sure that we have the paperwork and everything in front of us. So as questions arise, feel free to ask them, because I think that this lack of clarity, and we're seeing it from our clients, we're seeing it from our consultations, we're seeing it from other operators that we are, affiliated with and know and talk to throughout the state of Michigan, as to what exactly is the state allowing people to do right now. Because, and just from the framework, and for those that are less familiar, we are transitioning from what was this caregiver model to this commercial market. And the state has developed Rule 19, which says that temporary operations under limited circumstances are available with certain conditions. And in order to do that, you're going to be effectively proposing a marijuana facility, and that you would be operating, even though you don't have a license.
Yep.
And so we just want to be clear that, this isn't a caregiver being a caregiver. We never needed to stop. Nothing in the rules ever said a caregiver had to stop being a caregiver and treating their patients. So that supply chain, that use, those plants that are registered, if you have up to the max amount of 72, that is not what we're talking about. You never were told you had to close. And you still won't be told you have to close even after licensing begins. This is purely those people that are caregivers and or other operators that are trying to be growers, processors, or provisioning centers prior to the state issuing those licenses.
Right. Would you like me to give you just a quick run through of Rule 19? So Rule 19 starts with a very important sentence, and it kind of emphasizes what Craig was just saying. It says, an applicant for a state operating license, that means you're an applicant, may temporarily operate a proposed marijuana facility that would otherwise require a state operating license, if either of the following two apply. And before we get into what those two things are, it's specifically talking about conduct that would require a license, but you don't have one yet. So if you're a caregiver or a patient, you don't require a medical marijuana facilities licensing act license. You are a patient or a caregiver. This is only for conduct that isn't that. It's conduct that would require you to have a license. So you can't go do something that an MMFLA grower or processor or provisioning center can't do, but it falls into this little circle. It's anything that's more than or different from what caregivers and patients can do, but within the scope of what any of the 5 license types under the MMFLA can do.
And I think that the real key language in that sentence you quoted is temporarily operate a proposed marijuana facility.
Right.
That word, marijuana facility, those two words together, don't exist in the MMMA at all.
Yep.
They don't exist. There's no facility for a caregiver. It's a caregiver grower. And so when we add the word facility, this rule from Lara is contemplating that you're going to be stepping out of that old law and operating within this new law. And I think the storefronts, and we know that the conversation from the board and from Lara and from all the different discussions going all the way back into August when the board member Bailey first made his motion to try to stop all storefronts from operating completely. And the original date was September 15, and then it kind of went through this whole rigmarole of discussion, but ultimately led to Rule 19. Throughout that conversation was the idea that storefronts are not legal under Michigan law. And how do we then allow these storefronts that are operating as caregiver centers to transition into being a marijuana facility?
Right. And let's be clear, they are not legal under state law. Because one of the requirements is you were a facility previously authorized by your local municipality. And the biggest problem with marijuana in Michigan prior to the MMFLA was confusion. There was state laws that let you do certain things, and in some cities around the state, you could do things that weren't exactly that. And we had a system where in some cities there were open and operating businesses, and in others they would be shut down for felonies. So
and why we can get into the equities of that, and certainly the idea that people were sitting in incarceration in the northern part of the state for doing activity that was approved in the southern part of the state is ridiculous.
Right.
We're not commenting on the merit of that by all means. We are in agreement with the operators that this injustice and inequity needed to stop, and this is why we're transitioning over. But taking that concern aside, we do have operators that are still operating right now as these temporary facilities, be it storefronts or be it grow facilities in particular, that might actually have more than the caregiver plant total is allowing. And that gets us to that. This is what happened in Detroit, where they were acting as a proposed marijuana facility, consistent with the application that was sent to the state, and they received a letter from the state indicating they're okay to do that. Right. And so, despite that, they were still enforced upon. And now we're kind of going to hopefully hear how that unwinds through the various channels. But notwithstanding that, I think we want to make sure that there's no lack of clarity here. We are not advising you that being a temporary operator and going in and trying to get 1,500 plants going before you have your Class C license is something we are advising.
Right.
Right.
We are just discussing
right.
what Rule 19 might mean for you. And as Craig said before, in the conversation leading up to it, it was always in the context of provisioning centers and dispensaries. But the rule itself does not limit itself to provisioning centers. It says marijuana facilities. So what that means is there's 5 types of licenses. A provisioning center is just one of those 5 types. This rule allows you to temporarily operate as a marijuana facility that would otherwise require a license, which means that opens up the opportunity to growers, processors, secure transporters, testing labs, safety compliance facilities, in addition to provisioning centers.
That's right.
So,
and Edgar, you had asked, a very fair question. So, a temporary operator is still not legal, and I think that the true answer to that is you're still temporary until you're licensed and you're approved by the state of Michigan. There is peril in operating with just local permission, and then of course we're learning where the bounds are within that operation right now of what is actually a storefront. And if you are, for instance, operating a storefront, how did you source your supply? Right. I think that's a very fair question as to what products are on those shelves, because we don't have licensed products.
Well, that leads us right into where Craig and I have very complicated conversations. So, in theory, from the top down, Rule 19 lets you temporarily operate a medical marijuana facility. But all of these facilities operate differently. And what we can't assume is that Rule 19 lets you do anything the Medical Marijuana Facilities Licensing Act doesn't let you do. Well, if you're a provisioning center, you have to obtain products from growers or processors. Those products have to be tested by a safety compliance facility, and they have to be moved by a secure transporter. So Rule 19 doesn't let you do things regular growers that have their licenses can do. So if you're a provisioning center and you're operating under Rule 19, the problematic question is, where did the product come from? Was it tested by a licensed facility? Or the alternative, was it tested by a temporarily operating safety compliance facility that's also operating under Rule 19? Was it transferred by a secure transporter who's also operating under temporarily operating Rule 19? Was it sourced by a grow facility that's operating under Rule 19? Because if it wasn't, why can you do something that someone with the actual license approved by the state, reviewing you and approving you, can't do it? That's the problem. And it is. I mean, I hate to use that language, but it kind of is.
Well, again, let's just back off for a second.
Sure.
There's going to be, first and foremost, you've heard Travis and I and Nick as well. We've always been very complimentary of Laura and how they've been transitioning this. So this isn't necessarily something that we want to be derogatory about. But what we want to do is try to provide some clarity and have the appreciation that we're all probably going to look back on 2018 in this transition, be it in 20 and 21, 22, as like, man, you remember how hard it was in this transition? And so, that's what we're talking about. And thank you, James. I appreciate you. We know you're talking about the whole thing in general.
If people are reading the comments, they might not see the timestamp necessarily, so I appreciate that.
But in reality, what we are speaking to is we want to provide some clarity. We want to give people, the last thing we want people to do, and this is very important as well, is go into this temporary operation, spend their money, and go down these paths. Well, the language says it won't be held against you. Your conduct is still something that will be reviewed. Right. And so the act of being open isn't the reason to be denied. How you operate may be a reason to be denied. Right. And so and we've seen the board where there's been presumptions. The word presumed is used far too often. I'm doing a blog on appeals right now because, quite frankly, the last set of denials were ridiculous and need to be appealed, but that's a whole another show. But it does kind of highlight the idea here insofar as, you know, there's nothing that says because you're given early permission, you have the right.
Correct.
And we want to be clear that you still have to watch your back until you have that license, and then you watch your back as a licensee.
Right. And I'm glad that you said this, Craig, because I am very complimentary of law as well. They're doing the best they can. They don't write the statute. They have to implement the statute under rules. Those rules are currently emergency versions, so they're not finalized. I mean, and they did their best to do what they could to meet the need that the industry demanded of them, which is how are patients supposed to get product when they've relied on these businesses? So I compliment them on doing it.
Yeah.
But what we're focusing in on today is, okay, well, here's what we have, and what does it actually do? And we can be critical of that because, unfortunately, it's problematic. So I showed my hand for provisioning centers. The one license type that I personally feel makes sense under Rule 19 is the grower license, because that is the starting point for the Medical Marijuana Facilities Licensing Act. Assuming that you have plants lawfully in your possession and you're under the plant counts for the type of license you're pursuing, what doesn't make sense to cultivate those plants temporarily and save those products for the point when you ultimately get your license. You enter them into metric, you have them tested by the labs when they're up and running, and get them in the system. It fulfills the need of Rule 19, which is patients don't want their access to medicine cut off. So if we don't have growers currently getting products ready to go, there's not going to be any stock in the system for people to buy.
So, and I think that that's a very good point. And where we find the ambiguity between how the state set this up is we have the original MMFLA, we have the amendment to the MMFLA that came out early this year. And in that amendment, it actually talked about how to propagate your facility if you're a grower or process license. And it used language that said within 30 days of getting your license, that a grower license can actually receive from a caregiver who will become an active employee of the facility plant seeds and seedlings. And then in the processor license, it adds the word marijuana plants or usable marijuana. And so this is the first time where statutorily we're seeing the transition. Mm-hmm. And then what happened is Laura developed rules around that, and then they've also answered FAQs. Yeah. Be very clear, the law is the statute. Yeah. I'm pointing literally to the statute book here. Okay. The rules and the FAQs are advisory bulletins. They are not the law. And so what we want to be clear of is that you still have to know what the statute is and then continue to move through that process. And so, you know, in that vein, when Travis is talking about how a grower kind of meets this temporary operation, it makes sense. So I'm a grower. I have the legal right to grow marijuana because maybe I already have a caregiver license. Mm-hmm. But those plants under my caregiver license are allocated to my patients. So they're really my patients' plants, and I'm watching over. Now, I have those plants in a facility, and I'm adding to those. So let's talk about supply. What happens? So I have now 200 plants because I'm growing up to be a Class A grower, let's say. But, you know, the fact of the matter is that that's far more plants than my patients are allocated. But I still need to take care of my patients, so how do I supply them? Right.
And it's important to remember, a grower with an actual license can't supply product to patients either. So you're in a transition period where you were a caregiver, or part of your team were caregivers, and they are going to be growers. We all know that once that license for being a grower is issued, you can't be a caregiver anymore. You need to be a caregiver for 2 years. You get a license. The members of your team that were caregivers have to stop being a caregiver. So when I see this system in place, here's what I think. I think caregivers can have the number of plants they're allowed to have based on their patients, and growers.
All right, are we back on, everybody? Again,
sorry about
we
that.
seem to be getting some in and out on our Wi-Fi, which is
our power's been flickering too. They're literally paving like feet from our router, so apologies.
Yeah, and again, hopefully people are clear on where we're going. I did see a couple of questions pop up, and Barton, our principal here, has asked one that I think is very pertinent, which is what happens when the police and the prosecutors charge, people who are operating as a temporary attestation. I think this is where the defense comes in. The short answer is they shouldn't be enforcing upon them because there should be communication between the local community, the authorities, the state, and then, of course, the enforcement bureaus, that these attestations and temporary operations exist. Now, Does that mean that if you have a temporary operating permit, you can now have 4,000 plants? No. So if they come in and they see you're over the number of your proposed facility, that's a big problem for you. But if you're within the rules that you were granted, what we should have is no enforcement. And we should have the opportunity to take that information, use it as an affirmative defense, and hopefully cause the prosecutors to drop all charges and return all monies that were in properties that were civilly forfeited.
Right. And to answer the question directly, I believe the intent and how I would read Rule 19 is if you're under Rule 19 and you're being charged with something, Rule 19 lets you, in that very limited circumstance, use the defenses all medical marijuana facilities can raise if they were licensed, operating within the scope of their license.
Immunity. That's right. That's the key word. Nothing in any of this law made medical marijuana per se legal. What it does is it provides immunity for defenses.
Right. So if you are a Rule 19 operator and you've been having a problem and you're facing charges by the prosecutor, and you can establish that you were appropriately operating under the scope of Rule 19 and you were appropriately operating as the license type you were attempting to eventually be.
Yeah, this is, hello everybody again. This is becoming a little frustrating. So,
apologies.
Maybe we'll try to flip it. If we get lost again, we might take an extra moment and try to flip to a different network. But we'll keep plugging away here, and again, with our apologies on that. There was also a question about up north and dispensaries, and let's be clear, because what you've done already is you've read the first paragraph, or really the first one.
Yeah, we didn't go through the rest of it.
The second part of that, maybe not quite the second, but within that is the ordinance had to have been established locally by December 15, and or you had to have been approved to be locally operating by then. And then your application to the state had to be received by February 15.
Right.
Even in the amendment to the rules that came out that extended the June 15 date to September 15, it didn't actually say, well, communities that started up in March and approved people in March can now roll back in and suddenly be available to operate.
So while this is a very interesting topic, the set of people who can be under Rule 19 is closed. Like, no new people are under Rule 19. So, the problem is we have a lot of them out there in Michigan, and they should be careful. And people who are in favor of them and are customers of them or support them need to understand that, like, while it's great that they're fulfilling this need, they are taking some significant risk if they're not being very careful.
Yeah, and by no means are we agreeing that law shouldn't allow communities that came on later. A big chunk of our time is going into communities and trying to get them on board. And certainly those that came on board since February should also be allowing temporary operation, but the state rule doesn't allow for it. And so if you have that, and even if they want to give you an attestation, City of Warren, for instance, it's a good example because their storefronts are going to be coming online soon. That happened after February 15th.
Right.
That happened after December 15th.
So they have to get in the queue like every other new applicant and get approved before they're allowed to do anything.
So let's not assume that just because your community came online last month that they're going to now allow for local operation. And that's unfortunate because we would hope that in those communities the idea is to propagate, get people set up, get them ready for what will be the future in our commercial market. But again, unless you had that submission in by February 15 and the attestation by then, I would say pause all things until the rule changes or you have your license.
And understand that there are, in the statute, ways to transfer plants in from caregivers, transfer seeds and seedlings in.
Right.
So it's not like you have to start from scratch, but unfortunately that is the advantage Rule 19 operators have if they're able to safely operate, is they can do things license holders can do without having that license yet.
Right.
In theory.
Now, a grower can still have their caregiver grow within their facility with the same conditions and requirements that were under the MMFLA. In other words, you can have your 72 plants allocated in a private portion of your facilities. You build out the rest of your facility. So, you can still maintain your patients and all of that, even if you're within the large facility as a whole. But, that's again, you got to make those choices as you're beginning to get your local approval as to where you want to continue to do your caregiver grow. But, I think we touched on briefly, and I want to circle back now to talk about the caregiver grows and processors. And, one of the debates that Travis and I have is, all right, so I'm a temporary attested grow facility. I have a Class C license pending. I currently have my 72 plants allocated, and each month I am actually just taking what the usable marijuana is and packaging them pending my testing opportunity so I can bring it to market.
And the reason you do that is this. We know products grown by growers need to be tested before they can be even transferred to processors. So the safest thing to do, without requiring you to do anything you're required to do as a grower, besides metric not being up and running, is I have plants, I grow plants, I stay under my plant count, I store marijuana in batches until they are ready to be tested by a safety compliance facility.
This is where we split. I'm very cautious to say that, under the current rules, caregivers can only have a certain amount of marijuana for their patients. Usable marijuana limits have been litigated up and down throughout the state of Michigan since 2008. 2.5 ounces per patient, period. And my fear is that a grower who's got, say, 500 plants or more going right now is going to have a large stockpile of usable marijuana at the time they're licensed. And that'd be great if we can get to that point. But what happens if law enforcement comes around? Does this immunity really allow for that yet? My caution is that we still need to maintain our supply. So to have plants that are growing and not creating usable marijuana is different than having plants that have been cultivated. And so we know that through the MMA and how that's been treated, be it drying or usable and all those definitions. Again, there just has to be this air of caution that says, is it worth it to cultivate now, or should we just let these plants turn into monsters? Or maybe time ourselves such that we're just learning the technique and then we're literally, scrubbing them and composting and doing waste disposal on it and getting better at our craft. There's a debate to be had between all of that.
All right, well, again, I'll preface this because I want to be very clear. I am not a fan of doing anything under Rule 19, but if you are, and if I had to try to defend you, here's what I would say. The very first sentence of Rule 19 is, if your conduct would otherwise require a license, Rule 19 applies, right? So if you happen to be, in that position where you're claiming your Rule 19 protection, you can do a couple of things. You can have plants come lawfully into your possession. We know that there are ways to do that under the statute. Now, the statute does not contemplate Rule 19 at all. Rule 19 is not in the statute. And remember, the statute controls. And that's, I think, where Craig and I are going to have some issues. But we have to assume Rule 19 does something, right? It is an administrative rule. It isn't a fully fleshed out finalized version, but it is better than an FAQ or a bulletin or something.
That's right.
It says you can engage in the conduct that would require a license. Well, the grower's license allows you to cultivate marijuana. That's what it allows you to do. Assuming you can get those plants in legally, you can cultivate those plants. Otherwise, if you had to stay under the restrictions of what caregivers can do, you wouldn't need the license to do it. So if you can have a higher plant count than 72, why can't you also harvest those plants? You need a license to do either of those things. Now, what I don't think a grower should be doing is taking products that are grown by caregivers intended for those caregivers' patients, because no grower at all is allowed to have usable product. They're allowed to take plants, they're allowed to take seedlings, they're allowed to take seeds. They are not allowed to take any other materials from caregivers at any point, whether you have a license or not, whether you're in your 30-day transfer window or not. So what I would recommend is if you're going to be a caregiver and you're going to continue to be a caregiver until you get that license, you have to be very careful. Your caregiver plants are for your patients, and you should only be growing the amount that is medically necessary for your patients' severe debilitating medical conditions. And then if you have plants that are for your grower, those are your grower plants. One plant can't be both. You can't have a patient plant that's also being harvested, and if you have overages, going into your grower pile, because there's no way to legally transfer those products that you're harvesting from the 2008 Medical Marijuana Act into the 2016 MMFLA. That's how I read Rule 19.
Yeah, I mean, I go a little bit farther to say that when the statute actually says that after you get your license, you're really only allowed to bring in from caregivers plants, seeds, and seedlings, the way Travis just described, that, if they had contemplated usable marijuana being something that the grower will have already in hand, that language would have been included. Why do I think that? Because in the processor amendment, when we look at 502 and how that was amended, it does actually use the language of usable marijuana being available to be brought in by a caregiver. Now, how much can a caregiver have? no more than 15 ounces if they're registered for 5 patients and they themselves are a patient. So that's the maximum they should ever have on hand, period. But their plants would also be allowed to come into that facility for a processor. And so when they actually use the word usable marijuana elsewhere in the statute but exclude it from 501, that's where we get into the legal debate of intent of the statute and stuff like that. And so, again, the caution here is don't jeopardize your license, the future of your licensing on short vision of what you're doing right now. You know, if you want to get your craft going, if you want to be better at it, if you want to try to get a little bit ahead of the game, just know that with every step forward that you're taking it closer and closer to a line that could be questioned by Laura. Keep in mind, too, we know this as well. You're not getting your license until they've already come in and inspected your facility. So as we go through phase 2, which we haven't seen the board do of any of those yet, but as we go through it, we know they're going to be on site. If you have a big stockpile of marijuana on site, it might prove to not be an issue, or it might prove to be part of the report back to the board and being advised that this is what you're doing. And again, raise the question of whether or not that gives them cause to say you've been doing something not appropriate. Just because you're allowed to operate doesn't mean that, you know, it isn't going to be questioned. It just means that that in and of itself won't be a reason to deny you.
Right, and we have seen this board be very, very particular about problematic features, whether those features in and of themselves should have been disqualifying or not. So, again, Rule 19 says you can do something. It doesn't say it guarantees you a license. It doesn't say, you know, it implies that that type of conduct shouldn't be held against you. But if that conduct is in addition to other factors that are going to be under review, you can bet everything will be highly scrutinized. So, you know, if you're going to be a temporary operator, you should ask yourself the question, do the benefits outweigh the risks?
Absolutely. Certainly, there's no money in it at this point for purposes of that usable marijuana isn't being sold. So, you know, what's the upside of creating it other than maybe getting a head start towards the marketplace? You know, is that a harvest or two away anyway? So that's the balancing act that you got to find. Now, normally in our Cannabusiness Live, we wouldn't have been cut off 4 different times due to Wi-Fi issues and stuff like that, but we generally keep a timer, and you know, we try to keep our shows to roughly half hour, and I think we're right around that 10:35 marker now. And so, yeah, although it's been a bit choppy, and we probably can go on for another 40 minutes on the topic, I don't want to carry on too much longer. But you know, I think that there was just a couple, you know, just minor items that let's kind of top off on as we go through it. So the FAQs come back from the state, and there was one in particular that you and I had discussed before the show today. It's talking about what I should do with my marijuana, you know, in the event of the transition period. And so why don't we talk about that for a second? Because I think there's some good advice in that, and at the same time, another cautionary tale.
Right. Well, there's 2 FAQs we were talking about before the show. One specifically says, what do I do with my current marijuana inventory? What are the transition periods? And this isn't specifically talking about Rule 19. So it's, you know, this is in general for anyone who's in the license system. You know, what do I do with inventory? And unfortunately, the FAQ uses the phrase marijuana products. Now, that can be a big catch-all for a lot of different things, and it's not being very specific about what products we're referring to. But under the statute, thanks to the January amendment made to the MMFLA, in this FAQ, we know there's a 30-day transition period where if you're a grower or a processor and you have a caregiver, as you're required to have at least one of, as part of your team, there's a window where you can bring in plants, seedlings, and seeds. You can bring in those products into the system. And then beyond that, there's going to be an ability for you to acquire those types of materials at any point. Whereas in that 30-day window, with caregivers that are either members of or employees of your operation, you can bring in their actual plants. After that 30-day window, you can bring in seedlings and cuttings and tissue cultures and things, but not plants. So there's this rule's contemplating bringing those things in, but not all the license types can bring things in. It's talking specifically about the new statute that was amended that talks about growers and processors specifically.
And this is where, you know, Travis would lean on the word marijuana product and thinking that usable marijuana would be indicated as marijuana product. this is where my reservation would say, as a grower, you're only allowed to bring in plant seeds and seedlings, which are a marijuana product, but it's not usable marijuana. And so that lack of clarity from the state causes my yellow flag to go up to say, and just where do we want to err on the side of caution? And
just to be clear about what we're referring to, we're not talking about caregivers transferring product. We're talking about product that isn't in the system yet, that you might have grown as a temporary operator grower, stockpiling it. There's nothing in this saying you can bring that in. I mean, it makes sense that you should, because what else does Rule 19 mean? But we don't see any language in the law, which is the most important, that says you can do that. There's an FAQ that uses the word product, and it's not very clear. But if you look to, you're going to have to apply Rule 19, which is in itself unclear, to a statute that doesn't contemplate it. And we again have a question. Well, that's great. Okay. We can bring in plants. We know that. So maybe we can bring in more than 72 plants, But we're still unclear if we can bring in what we harvested from those plants, because nothing says we can do that.
And those questions hopefully will be answered over the coming weeks and months by Laura. And, to the extent that they've been trying to be in front of these issues, again, they've done a good job of it. We hope to have, in the future, some guests on our show that could help answer those questions as well, and we plan on digging in on all that.
Sure.
We've taken up quite a bit of time today, so why don't we just kind of do our best to provide a quick summary and conclusion of it. I believe that as operating and being in this transition, to me right now, the risk reward is such that I'd err on the side of caution. As an attorney, we're always risk averse, and it's just our nature, or at least advised that way. But this is where it's better to get your license and move forward than just make assumptions about where you're at right now. How you deploy your money, how you deploy your capital, how you deploy your resources. All those decisions are being made for the future. And to jeopardize that over what could be a few dollars today and or what might be the head start, just find that balance and be cautious. Know the rules, know the law, and ask advice. Don't make assumptions.
And just to add on that, from my own personal take, I respect the attempt that was made under Rule 19. I think patients need access to medicine. But if you truly are in this business to provide medicine to patients and you're shut down because you did something outside the scope of it, that means medicine you're unable to provide to patients in the long term. So in the short term, there is a huge need. Our laws aren't perfect. They're figuring things out. It'd be great if patients didn't have to deal with some disruption as we transition into this industry. But if the operators right now, find themselves in some sort of trap because they were trying to do more than they should have been doing right now safely, that's going to prevent them from creating new medicine for years into the future as opposed to months. So it's difficult for me to say because I would like nothing more than there to be as much access to patients to get the products that they need. I truly believe that's important. But for operators that want to be the ones doing that, there are significant risks, and you should be very aware of what those are.
Absolutely, and just keep that caution in. Don't give up. Your future for today is really the bottom line of it all. We have a lot more to talk about. We'll be having more shows here in the very future.
Maybe some funner topics.
Yeah,
more fun.
But you know what? I do appreciate the conversation that was created by it, and it's important that we continue those conversations. And thank you, Kathy. We look forward to coming on again. We should be on next Friday, and our schedules kind of impact that sometimes. We have court cases and some other things, and Friday mornings are kind of an agenda morning, but we also find it to be a really great time for these shows. So we'll continue to do our best to provide them live. And, if you have any comments or you want to see a particular question us to answer, feel free to reach us at Cannabis Legal Group on Facebook. Find us on www.cannabislegalgroup.com. Ask those questions. We'd be happy to develop a show around a particular topic. If
we have before as well.
Yeah. So this is one that hit us hard because when we saw that happen in Detroit, and the more we reviewed it, we just wanted to continue to engage the community about this. Be smart, be safe, and be wise. Enjoy your weekend, everybody. For Craig Aronoff,
Travis Copenhaver.
Have a great weekend. Thank
See
you
guys.